Last year, I argued another case in this line called Melendez-Diaz versus Massachusetts. And I want to suggest to you that Melendez-Diaz is, in a sense, the Blakely case in this line of jurisprudence. I think Melendez-Diaz is the hard case, whereas Crawford was the easy case. Melendez-Diaz involved the question whether, after Crawford, forensic laboratory reports are testimonial pieces of evidence, so that the prosecution can't introduce forensic lab reports without bringing the person who wrote the report into court and putting the person on the stand. Now, it doesn't take much reflection to realize that if you look at the framing period for how they dealt with forensic evidence, you're not going to get real far. I can say that I did some research with a student at Stanford, and the very, very best we were able to find was a line of cases from the mid-1800s involving prosecutions for adulterating milk. And so the prosecution would bring a chemist into court who had analyzed the milk, and the chemist would testify, and he would come into court and testify that the milk had been adulterated, in his opinion. But for obvious reasons, that only goes so far, and again, what you had in Melendez-Diaz was a situation of the Supreme Court having established an originalist-based principle and now being confronted with a utterly modern question in criminal procedure, and confronted with the difficult question of whether to apply that in modern times. The same five justices who I was speaking of in Apprendi and Blakely wrote an opinion in Melendez-Diaz applying the Sixth Amendment right to confrontation in this context. It's another opinion by Justice Scalia. And the reasoning is much the same as it is in Blakely. We have a rule that is established that prohibits, another way to put this is it prohibits trial by affidavit. And what is a sworn forensic report from somebody saying that a substance is cocaine, or the defendant's fingerprints are on the gun, or et cetera, but the modern equivalent of an affidavit. And so even though the framers didn't precisely bite down on this question, it's appropriate to apply this rule strictly today. The dissent in Melendez-Diaz, written by Justice Kennedy, looks a lot like the dissent in Blakely, written by Justice Breyer, and a separate dissent written by Justice O'Connor. It pushes aside history very quickly and says, it's almost like saying, I don't care what the framers would have thought about this. This makes life hard. It makes life hard for prosecutors, it makes life hard for legislatures, and it's going to be too burdensome on the criminal justice system, and we're not interested in applying the rule here. So before I turn it over to Professor Bibas, let me make a few observations about why I think the Supreme Court got it right in Blakely and Melendez-Diaz, and why I think it is a welcome and appropriate development for the Supreme Court to be taking originalism seriously in criminal jurisprudence and criminal procedure, even when it's applying it to unquestionably modern circumstances. Let me give you three reasons. The first, in my mind, goes to just the very nature of a Bill of Rights. If you pick up the Bill of Rights, and particularly when we're talking about criminal procedure, if you pick up the Sixth Amendment, there aren't that many things in there. There's the right to an attorney, there's the right to trial by jury, there's the right to confront witnesses against you, and there's one or two other things. That's not a long list. And I think it's not a lot to ask. And I don't think the framers would have thought it a lot to ask, and I don't think modern judges should think it a lot to ask, to apply those few precious rights with serious vigor today as yesterday. The rules of criminal procedure, all kinds of statutory developments can do all the adjusting to modern times they want, but the robust ground rules for criminal procedure ought to be followed. Now you might say I'm begging the question when I say that, because of course that depends on what it means. So let me turn to my second observation about why I think this makes sense. Again, if you care at all about originalism, and I think the court does in various ways, at least different justices do in various ways, some more than others, but I think it's undeniable that the framers were deeply, deeply suspicious of governmental power. Again, that's why the amendments were insisted on in the Constitution. And Yes, as the court said in Crawford, the framers perhaps had on their minds more the great state treason trials like Sir Walter Raleigh than to take the other side of the spectrum in Melendez-Diaz, an ordinary run-of-the-mill drug possession prosecution. But I don't think that's a difference of kind. I think that, if anything, the reason the framers were worried about the great state trials because the problem of governmental overreaching against the citizens' will. And I think that, if anything, in the modern day, and this is where I think I will map things onto the modern day quite explicitly, the criminal justice system, when it deals in these everyday cases, in these ordinary cases, those are the ones where I think the criminal procedure rights are most important, because they're the ones where there tend to be indigent defendant, the forgotten, the downtrodden in our society, and people who really don't have the eye of the public watching their cases. We need them to have certain backstops that they can insist on. Else they just get churned through the system without any protections at all. And finally, the final reason I think these decisions are correct which is related, is because they curb the power of judges, which I think again was a key consideration for the framers. When you read the dissents in Melendez-Diaz and in Blakely, the overall theme in those dissents, or one of the themes, is: look, we can trust judges to do this. Why do we need to put the prosecution to regular burdens of proof to the jury? Why do they have to prove this beyond a reasonable doubt to the jury? Why do they have to bring this witness in and put him on the stand so the jurors can see and the jurors can decide whether the statements are reliable? We can just trust the judges. Well, again, I have enormous respect for justices on the Supreme Court, right down to state trial judges across the country. They're all trying to do a job. But there's one thing that the framers, I think, were really worried about, was giving too much power to judges. And when judges can decide for themselves how much is too much, stick my finger in the wind and I can decide as a policy pragmatic reason when I think I should balance away the defendant's rights to the prosecution. I can tell you, as somebody that knows a little bit about the criminal justice system, whenever I pick up an opinion that says we're going to balance the interests of the state in this criminal prosecution against the interests of the defendant, I know who's going to win that case. What we need are a few firm, bright-line rules that defendants have the right to insist on when necessary, and that judges are bound to enforce even when they don't want to do so. With that, I'll turn it over.
Professor Bibas.